Start the plenary session 3. And the session is, what does girls' human rights work entail and what impact does it have? And I'm going to hand you over to two of our young experts, Lauren Bryant and Razan El Shazali, and they're going to moderate these sessions. Thank you so much.
Good afternoon, everyone. My name is Lauren and I'm a young expert, as Sultana said. I'm also a policy and advocacy campaigner for several different nonprofits, in which I lobby for gender-responsive policy making and tackle issues such as gender-based violence.
Hi guys, Assalamu alaikum. My name is Razan and I'm a final year politics student at the University of Cambridge. So I'm originally from Sudan and I live in Qatar and now I'm in the UK, so it's a lot happening. And hopefully next year I'm going to be doing a master's degree in international development.
Thank you for joining us for this panel discussion on the power of promoting girls' human rights, in which our expert speakers will be exploring the urgent need to tackle gender-based discrimination and violence.
So this panel is going to cover themes such as the eradication of female genital mutilation, child marriage, and other harmful practices. By empowering girls to learn about both the theory and the practice of human rights, we can be the change.
Our first speaker, who we had the pleasure of meeting just now, is Zoe Harper, barrister at Doughty Street Chambers. Zoe's expertise lies in representing victims of trafficking and gender-based violence. She is well regarded for her sensitive yet effective approach when working with vulnerable clients, including those impacted by traumatic experiences such as torture, alongside mental health difficulties and other serious health concerns. So if we could welcome Zoe to the stage.
Thank you so much. It's brilliant to see so many exceptional young women interested in human rights in the room, and I've had the pleasure of meeting a few of you just earlier. I'm going to start my presentation by talking about another exceptional young woman called Henriette Siliadin. Henriette was 15 years old when she was trafficked into France from Togo. She had been brought by a person who had agreed with her father that she would work until her air ticket had been reimbursed. She would have her immigration status regularized and would be able to go to school in France. She worked for free for that couple for a few months, age 15, before she was then lent to another couple in France. She worked in their house without respite for several years, taking care of the children and doing domestic work. She worked 15 hours a day with no day off for several years without ever receiving wages or being sent to school. She had no identity papers. She was given not enough food and had to sleep in the children's bedroom. She had some freedom of movement because she regularly left the house to take the children to school, but she did not have any freedom of choice. She was a teenage girl in a foreign land, in France illegally, and in fear of arrest by the police, a fear that her traffickers nurtured. After some years, Henriette was identified by a woman in her building who questioned the amount of time she saw caring for the children, and that woman informed the police. Unfortunately, Henriette Siliadin's case is not exceptional or confined to France. In the UK, thousands of women and girls are found to have been trafficked into slavery and exploitation every year. In 2022, which is the last year for which full annual statistics are available, over 3,600 women and girls were referred to the National Identification Mechanism as potential victims of slavery and exploitation. Nearly half were under 18 years, like Henriette. Women and girls may be trafficked into all types of exploitation in the UK. For example, labour exploitation, such as in unpaid work in nail bars, in cleaning, and increasingly in social care work. In criminality, many young girls and women are forced into cannabis cultivation, but significantly they are represented in domestic servitude and sexual exploitation, or exploited in ways in which sexual abuse is part of the picture. The UK is both a source and destination country for victims of human trafficking, which means as a source country, UK nationals themselves, particularly young people in vulnerable situations, are at risk of trafficking. And people are trafficked to and within the UK for exploitation. People also flee to the UK for safety, having been trafficked or exploited elsewhere. People may have been trafficked, having fled situations of danger, for example, circumstances of conflict. Or in my caseload, it's very common for women and girls fleeing situations of domestic abuse or forced marriage abroad to become vulnerable to trafficking and further exploitation whilst escaping. But we know that the figures represent just a small percentage of people in situations of trafficking and modern slavery in the UK today. It can be very difficult to escape, and people may not come forward as victims for many reasons, including the fears that Henriette herself faced. What is exceptional about Henriette Seliadin's case was that she was supported by an NGO to bring a case that would then be considered by the European Court of Human Rights in Strasbourg. It became the first case to consider the rights of women and girls under Article 4 of the European Convention on Human Rights. Article 4 states that no one shall be held in slavery or servitude, and no one shall be required to perform forced or compulsory labour. Henriette was just 23 years old when she started that legal action, and it took many years to come to court. And to keep going among all the setbacks that she had in the domestic courts would have taken significant courage, and something that Henriette said she did for others who were similarly exploited. In France, she brought a civil case initially to obtain payment of unpaid wages for the years that she'd been exploited, and that was successful. But keeping a person in domestic servitude or slavery was not formally criminalised in France, and so her traffickers could not then be prosecuted. The Strasbourg court considered this particular issue and held that Article 4 enshrined one of the basic values of democratic societies in Europe, and that the conditions in which Henriette was held did amount to servitude, even when France tried to argue that she had the freedom to escape or seek help if she wished, because she was able to go out alone with the children. Significantly, the Strasbourg court held that the states have positive obligations to protect people against slavery and servitude, in this case by properly criminalising those forms of harm. It's not enough for the state to desist from placing people in servitude themselves, but they have the duties to protect also. And a later case, Rantsev in Cyprus and Russia, would expand on this judgment, and it would state explicitly that trafficking itself was a form of abuse that fell within Article 4 of the European Convention on Human Rights, and it would state explicitly that the positive obligations on states included both prevention, protection, as well as criminalisation of forms of harm. In its judgment, it referred to the obligations in the Council of Europe Convention on Action Against Trafficking in Human Beings. The UK is a signatory to both the European Convention on Human Rights and the Council of Europe Convention on Action Against Trafficking in Human Beings. The Council of Europe Convention on Trafficking defines human trafficking in accordance with long-standing international legal provisions. It sets out the need for proactive steps to identify and protect victims. It provides for recovery and reflection periods to offer women and girls and other victims of trafficking a period of safety to enable them to recover, escape the influence of traffickers, and take informed decisions about their legal status and about cooperating with the authorities to bring their traffickers to justice. There are provisions that require states like the UK to provide assistance to support victims in their physical, psychological, and social recovery. And also the international provisions require access to a residence permit, as well as access to the refugee determination process in circumstances where somebody might be at risk of return to their country of origin. Among other provisions, for example, non-punishment, that people shouldn't be imposed penalties for their involvement in unlawful activities where they were compelled to do so as part of their trafficking, and the criminalisation of trafficking and other related acts. With the right support, victims of trafficking and slavery can recover from their experiences, and Henriette Seliadin, from information that she's made public, is now a nurse, an author, a human rights campaigner, and has her own family. Sadly, The UK does not adequately comply with its protective obligations, and many others are unable to access protection, and particularly without assistance. Lawyers play a really important role in enforcing the implementation of the UK's obligation and ensuring that these are applied to all victims in need of protection. As young lawyers or potential young lawyers in any role that you are considering, you are likely to be able to find a way to advance the rights and protection of victims and survivors of trafficking in most kind of areas of law. Immigration lawyers like myself support women and girls in challenging removal from the UK to situations where they would be at risk of re-trafficking. My community care colleagues who specialise in access to housing and welfare support ensure safe accommodation or access to safe accommodation, which is critical to women and girls' sense of safety and the ability to recover. Employment lawyers can support women in applying for compensation or unpaid wages in the employment tribunals. And criminal colleagues will challenge convictions of women who have been prosecuted for crimes committed while they were under the control of traffickers. Commercial lawyers increasingly work with businesses to prevent modern slavery in supply chains. And moving away from law, other professionals also play an important role in identifying and protecting victims through health services, mental health services, and in NGOs in a wide range of roles. The situation for victims of trafficking in the UK is significantly worsening. The government has passed legislation that will make it even harder for women and girls to be identified as victims. And as the Council of Europe Convention explanatory notes states, identification is so important in order to be able to support women to access their rights. The Nationality and Borders Act 2022 was passed and creates provisions that would exclude victims of trafficking from provisions for identifying and protecting them where they arrive on small boats or other irregular means. And we know that there are such limited safe legal routes for people to access protection that this will encompass a large number of victims. And similarly, it will also, once the provisions are in force, exclude victims who have committed an offence or been convicted of an offence from the legal protections. Victims who arrive irregularly would have their claims for asylum deemed inadmissible, and they would be kept in limbo in the UK until they could be removed to any safe country, Rwanda, as you probably heard about on the news. The UK Supreme Court has ruled that Rwanda is not safe for determining protection claims. The Safety of Rwanda Bill, currently going through Parliament, seeks to legislate to state that Rwanda is safe despite the UK Supreme Court judgment. And the bill contains similar provisions enabling potential victims of trafficking to be removed without being properly identified as a victim or without the risk of re-trafficking being assessed. There are lots of reasons why this bill is not lawful or correct, but significantly, it will breach the UK's obligations under Article 4 of the European Convention of Human Rights and the Council of Europe Convention on Action Against Human Trafficking, with devastating impacts on victims of trafficking. One action that young campaigners can do now is to ask your MP to vote against this bill. 260 charities and expert organisations have spoken out already, so there's lots of information out there to learn more. And it's one thing that's very practical, even before qualifying, that young people can do to show solidarity and support to victims of trafficking. Thank you.
Thank you, Zoe. That was so insightful, especially to hear about the Rwanda bill, which I'm sure a lot of people are following closely with the news. Our next speaker is Coline Schupfer, who is an intersectional justice consultant at the Open Society Foundations. She has extensive experience in advocacy, research, and policy across Asia, Africa, and North America. So please welcome her.
First of all, thank you so much for having me here. It's a huge pleasure and privilege to be part of this incredible festival and to be here alongside such an incredible panel. So many of us in this room are studying law or are intimately familiar with the study of law. In my case, I studied law here in England and Wales in a system that teaches you to learn the rules one by one and to apply them meticulously to what's in front of you. However, this education didn't delve much into some really critical questions. Who crafted these rules? Whom do they benefit? And perhaps most critically, what kind of power structures do these rules uphold? Engaging in girls' human rights work, in my view, reflecting also my work and the questions I grapple with daily around law, violence, and power, requires us to confront these very questions. It requires us to scrutinize the very foundation of our legal system and ask ourselves, who do these rules serve? Do they serve us, or do they serve to maintain the traditional patriarchal systems around us? I started my human rights work providing legal aid to refugees and asylum seekers. And through this work, I saw firsthand how gender persecution and gender-based violence devastates lives. Despite this, and despite how widespread FGM, forced marriage, child marriage, and other gender-specific crimes are, there's no such thing as gender persecution under the Refugee Convention. As a result, women and girls fleeing gender-based violence face immense challenges because of this omission and because of a whole series of inequities within our system. As such, girl human rights work, first of all, means making sure that these issues are better understood. It means raising awareness, which this festival does, and it means making sure that despite these gaps, that we do our very best to make sure that no one falls through the cracks. It also means finding a way to the best of our abilities to make sure that accountability is reached and justice is served. Taking a step back, girls' human rights work also means ensuring we have a seat on the table. It means making sure that the perspectives of women and girls in all their diversity are taken into account when laws are being drafted, when funding is allocated, and when key decisions are being made to make sure our interests are really represented. So one part of my current work currently involves working with women human rights defenders to make their voices included and make sure that they are heard in key policy spaces where key decisions that impact their lives are being made. And working with them also to shift the dialogues and the discussions in these spaces. A part of this recently involved bringing 4 women human rights defenders from across the world to Geneva. And in the Geneva, they raised issues such as threats faced by their communities, gender-based violence, and the lack of safe spaces for women in their communities. They spoke at official events that gave visibility to their issues, reaching a broad audience, and they also spoke at bilateral meetings where they had the chance to discuss in-depth issues that gravely impact them in front of key stakeholders. And as with human rights work in general, it can be difficult to assess the impact of these sort of interventions. Did they make a difference? Were their words heard? Were they listened to? Will they lead to any follow-up? In our case, there were a series of small wins, small tangible wins. But despite these small wins, talking to the women after Geneva, the most powerful thing that they took home was a sense of solidarity and sisterhood. Many of them were most interested in what the other women human rights defenders were doing, and having identified shared interests and experiences, they were keen to keep in touch because the exchange offered so much light and so much learning for them. As such, to wrap up, girls' human rights work is about questioning the status quo, asking really hard questions. in order to forge a better world for everyone, where everyone can be free from violence and oppression. And it's also about building community. So here I'm going to quote one of my favorite feminist writers, Bell Hooks, who writes, "One of the most vital ways we sustain ourselves is by building communities of resistance, places where we know we are not alone." And I think this is a really important reminder today, at this moment of growing anti-rights and anti-gender backlash, at this moment where international justice is being questioned, as we know, in front of the International Court of Justice at the moment. And it's about building this community and about understanding the intersections between our struggles and about creating a global community that doesn't just understand injustice, but is also actively fighting against it. Thank you.
Thank you, Coline. I really liked that you highlighted that when wanting to work in a space like this one and create tangible change, I think it's really important to first understand and then question the foundations on which it was built. So I really like that. Our next speaker is Shabina Begum, who is a solicitor at Dawson, Cornwell. Shabina specialises in cases dealing with international child abduction, forced marriage, female genital mutilation and gender-based violence. She is recognised as an expert by the UN on child, early and forced marriages in the UK and has conducted pioneering research on the topic, championing the rights of girls and women and girls. So let's welcome Shabina.
Thank you very much for that very kind introduction. And thank you to the speakers before me. I can't wait to hear everyone after me as well. And thank you, if I can, Sultana, for this very generous platform. Now, before I start, can I ask everyone in this room to please stand up? And now you can all sit down. Thank you. So, over here is speaking to yourself over lunchtime. You know who you are. Remind me of your name? Gabriella. Gabriella, why did you stand up when I asked you to stand up? Thank you for thinking this. Thank you. Now, when everyone stood up, everyone consented to standing up, right? But no one questioned me. Gabriella assumes that as I'm an authoritative figure, did everyone else assume this? Or was everyone else also just being respectful that the speakers asked us to stand and therefore we must stand? Now, choosing to stand up because someone's asked you to, that's consent. Knowing the reason behind why you're doing something, that's informed consent. That's what I'm going to be speaking to you about. I asked everyone to stand up because we are the after lunchtime speakers. So I wanted to make sure that you're all still awake. So thank you for doing that. Now, so I, as a family lawyer, so I delve in international child abduction, but I'm going to be speaking to you about a portion of the work that I do, and that is child marriage. And I am going to refer to FGM work as well. Now, who here knows what the age to consenting to marriage in the UK is as of today? Someone saying 60? You've put your hand up there, yes. Can you identify your name and shout out a number? Yes, yes, with the cream. Yes. Raya.
18 now. I think they've raised the age.
There you go. Raya has been following the change of legislation. So I was on the pro bono legal team that worked on that piece of legislation where we raised the age of marriage to 18 without any exception in England and Wales. And that happened almost a year ago. What's the date today? 20th. So the 27th of February will mark 1 year of anniversary in England and Wales only. And whilst that's an incredible thing to be able to say today, when you think about it in the context of the fact that we're in 2024, so before 2023, the 27th of Feb, the age of marriage in England and Wales was in effect 60. And with parental permission, essentially, you could consent to that marriage. And does anyone know why child marriage or even getting married at the age of 16 can be so harmful? Just a guess, show of hands. I'm going to pick on people if no one volunteers. Raya, thank you. I'm going to come back to you, but I feel like you know the answer. And you've already volunteered once. That's very generous. Over there. Oh, yes, please. Yes, you put your hand up. Thank you. My other volunteer.
Yes,
tying back into the idea of informed consent, like as a 16-year-old, you don't have enough information both about yourself and the world to be able to be within that power dynamic consensually.
Thank you. So I think I missed your name, but just to.
Sorry, Sarika.
Sarika, thank you, Sarika. So what Sarika's saying, it's true. So it's about information, it's about autonomy. But actually, it's all linked to the human rights of young girls. And it's majority of girls that are essentially subjected, and I use that word very intentionally because it's a violation of human rights, subjected to a child marriage at a formative age. So I've represented clients from the age of 15, 16, 17, 18, adulthood onwards, who are subjected to either child marriage or forced marriage. What that does to you is, and the UN recognized this, it takes away a young girl's ability to keep studying. So that's right to education. It takes away a young girl's ability to actually properly access healthcare. Because how many 15-year-olds do you know who would actually be brave enough to either speak to a healthcare professional or even their family members to say, actually, I want to find out a bit more about what safe sex means, right? I personally still don't know many of them. And the other, and it's almost like a backlash eventually, is the right to economic empowerment, right? And I start with all of that because I really need everyone in this room to hold on to that. Because whenever people speak about women's rights or girls' rights, I don't like this notion of being othered. And this is the power of the event that we're in today. We're recognizing this as girls' human rights. And what it means in effect in the long run is we end up as a society on the back foot if we don't empower our girls right from the outset and let them make that informed choice of when they choose to marry. And it's up until last year, February, in England and Wales, we were saying that we will let 15, 16, 17-year-old girls be unprotected because the state will not take that responsibility to protect them, and that those really important years, they can get married if they choose to, and at the age of 18, they can then choose to get divorced. Actually, they never were asked in the first place whether they wanted to opt in. They never gave informed consent in order to then decide later on whether they want to get divorced, in order to decide whether they want to have children. Because once that first yes isn't yours, those later yeses are never actually asked for. That's the problem in this area of law for me. And this is why I take this very personally, because to me, it's the loss of innocence, it's the loss of opportunity, it's the loss of a future of every girl. Now, when we speak about it in an event like this, I see advocates, I see lawyers, I see trailblazers in front of me. So I'm actually shaking inside standing in front of all of you right now, because you all have so much power to really step up at your stage. So I'm going to share a story about a young person that did this, and this person is going to tell me when my time is up. I'll wrap up in 30 seconds if I have to, but essentially to make you all realize how much power you have. And I don't say this baselessly, okay? And I mean this very genuinely. So I represented a 15-year-old girl, and I'm not going to disclose any names, and I am going to change countries so that no one's identity is leaked in any way. So she was, let's say, from the Yemen. And I received a phone call from the school. I believe we've got a safeguarding lead down there. And so, and the reason I know you're also a lawyer, but it's so important to know who your information people are, okay? Even as young adults, because this safeguarding officer reached out to me, and it was a young girl from a school who suddenly disappeared. And this safeguarding officer called me up and said, Shabina, there's just something off about this situation. And usually what happens as a family lawyer, you go to your local authority. Now, the local authority were too scared to go to court because they felt like there wasn't enough information. What had happened is this young girl's friend, so another 15-year-old young girl, went to the safeguarding officer and said, I'm really worried, but my friend isn't at school and I think something bad has happened. That for me was the most powerful piece of advocacy that I've ever seen a young person do. Because what that then spiraled onto was this person This adult safeguarding officer gave me a phone call. I picked up the call, and I think it was literally a Thursday morning, Thursday afternoon, and there was a risk that this young girl's father was then going to fly out and join her in the Yemen. She had already disappeared as far as her friend knew. And it's information, right? So this young girl's friend said, I believe there's a cousin waiting for her in the Yemen. That's all the information I had. And so I had to make a decision quite quickly to go in front of a High Court judge, make an application. So the way it works in family law is if someone's been taken out of the jurisdiction, you issue what's called a wardship. You make an application for wardship for anyone under 18. And then I also had to make an application for a forced marriage protection order, because for me, that was enough information to say that there is a risk. And I went to court, got the order, and we can also get at the High Court, you can also get what's called a passport order, another very serious order, because you're essentially intervening in someone's right to travel. I got the passport order against the father. Now, the father, because there was a safeguarding officer involved, we did ask the school to call up and check with the father whether he had any travel plans. He was honest enough to say, yes, we're going on holiday. It was term time. So we then asked, well, can you get us more information about the flights? He tried to then dupe the safeguarding officer and said, well, I'm flying from Gatwick. Now, we work really closely with what's called the High Court Police. They're called tip staff. And so when I gave the information for these flight details to tip staff, this gentleman who's been doing this work for a very long time, he's like, Shabina, no flight goes from the Yemen from Gatwick at that time. He's like, I'm pretty sure it's the other airport. So he was shrewd enough to split his teams. Essentially, he got police officers sent to Gatwick as well as Heathrow. The father boarded the plane, by which point the tip staff officer had this passport order, a High Court order, saying that you must give up your passport and make this young girl come back from the Yemen. The tip staff officer and the police officers were able to actually get on the flight, serve this on the father before the flight before the flight actually went off. And they yanked the father off the flight, and we managed to actually bring the girl back. Okay. For me, that entire story pins on the fact that this 15-year-old friend was brave enough to say, my friend has gone missing. And we did bring the girl back. And for me, the unfortunate part of the story was when this girl came back in the jurisdiction, so I had to go and meet her after the social worker had met her at the airport. It was a social worker's description of her. So the social worker said she presented at the airport in a gold abaya. I don't know if most of you know what an abaya is. So essentially, it's usually like a black cloak, like that a lot of Muslim women will wear, and she had a full hijab on. But this girl had a gold abaya on, so it was very decorative, and she had henna painted all over her hands and feet. It was summer, so you could see her feet. And small descriptions like that, for me, that was a game changer, because I knew something had happened. And the unfortunate thing about, I'd say, forced marriage protection orders in the family court is you're dealing with families. And there is a risk that there's a criminal offence there. Forced marriage is a crime in the UK. So this young girl obviously did not want her parents to get into trouble. So when I then spoke to her, she would not tell me what had happened. So when I said to her, well, you know, why did you go to the Yemen? She first said to me it was a holiday. And I said to her, look, I've seen this note and it said you had henna all over your hands. Was there some kind of engagement? And she thought, oh yeah, it was my cousin's wedding. So the goalpost of lies that she was telling me kept moving because she was trying to protect her family. And whilst I'll always look at that case, and it makes me sad because I think there must have been a marriage that probably did take place. For me, the saving grace in that story is at least that girl was protected from a lifetime of maybe rape and all those other, the access, the human rights stuff that I was telling you at the beginning, she wouldn't have had access to. So she did go on to go to university. She wanted to become a lawyer, and I absolutely love that. I'm biased. And you know, she had good access to healthcare here, and hopefully she'll go on to actually live her journey of being economically empowered and making her own decisions. And I think sometimes in all of this human rights work, we forget the humanity of it. And for me, that's the beauty of representing young people. It reminds me why it's so important to make sure we keep trying our best as adults. It's so that those young people, you young people, grow and become better adults than us. That's the real motivation behind all of this work. So don't overlook any of the small pieces of advocacy that you do, because you don't know whose life you could already be changing. Thank you very much.
Thank you, Shabina, for that honestly really interesting story, and for, like you said, highlighting the humanity of the law. I think a lot of us look past that, and also happy early birthday to the legislation that you helped pass. Our next speaker is Katie Schwarzman, who is a solicitor at Wilson Solicitors. She is a specialist in public law and human rights law. She also represents asylum seekers and victims of trafficking and other marginalized clients. So please welcome her here.
Hi everyone, thanks for having me. That's a tough act to follow. I feel like I should get you to a dance, like upstage, the standing up, but mine's far less interactive. But yeah, I just wanted to echo what the other speakers have said, that if you want to do girls and women's human rights work, you can do it in any type of practice that you do, legal or not, because unfortunately inequality is everywhere. And kind of every sort of role I've had in my career so far, I've been able to focus on inequality and women's rights in some shape or form. So thanks for letting me indulge me to talk a little bit about that and the things that I'm really passionate about. So I work, as was just mentioned, representing migrants primarily. And these women, so undocumented migrants, who I represent a lot of, experience discrimination that all women face, but also compounding discrimination from the fact of their immigration status. And that's often compounded with other inequalities such as race, language, class, disability, and so on. So I want to give a bit of a background to the type of work I do and why I feel like it's often such an invisible form of inequality that really needs lots of people working on it. So some of you may know, but in 2010, the UK government introduced its hostile environment policy. So the idea behind the policy was to make the UK as hostile as possible to undocumented migrants that they want to leave, and to deter anyone from abroad coming or thinking about coming without the necessary papers. So they achieved this by blocking access to public services. So undocumented migrants or people waiting for their asylum application or waiting for an immigration application to be determined are not allowed to rent. They have to be in home office accommodation or have their own private money. They can't access many NHS services. They can't access mainstream benefits, and they're not allowed to work. So during this time, while they're waiting for their immigration papers to be processed, they pretty much are in limbo for years, and everyone knows the asylum backlog. That's a really long time. They might be on asylum support, which is about £45 a week, or trafficking support, which is a little bit more, but really not much more than that. So really living potentially in destitution for many years. And this policy applies to men and women equally, but the impact on women is so severe and unequal. And in fact, often I think this policy causes or worsens the abuse and violence that women face. So I'm going to give an example. I'm going to give two examples, which are a little bit depressing, but also hopefully inspiring, because the fight continues. They're not solved yet. But the first example is from very early in my career. I spent 6 months of my training contract at Liberty, which is a human rights NGO, and they do strategic litigation. And this was sort of my first experience of working on this sort of topic that completely changed my career trajectory and made me want to work in this area. So in 2018, Liberty and Southall Black Sisters, which is a frontline charity supporting victims of domestic violence and often those with precarious immigration status, launched a relatively new scheme, which is they launched a super complaint against the police. That's a scheme that allows certain bodies to raise issues on behalf of the public for systemic breaches or practices by the police that affect people. So this super complaint concerned the fact that there is a policy that the police share the data of victims or witnesses of crimes with the Home Office for immigration enforcement purposes. So the policy was basically that the police should rock up to a 999 call, and the first thing they should be asking themselves is not how do we protect them, but what are these people's immigration status? Obviously, there's loads of bias in who the police are going to be asking those questions to and who they might not be asking those questions to. But that means that if a woman calls the police because her husband has tried to kill her, that the police can share her data with the Home Office to start Home Office investigations of their immigration status. And it was one of those moments, was like, if this was happening, if more people knew about this, how is this happening? And I was like, no, this isn't happening. What? And it just blew my mind that this is actually just a policy that happens. There's not that much media coverage. There's a bit in human rights circles, but it isn't really talked about all that much, given how dangerous it is. So this applies to victims or witnesses of crime. So if you have the misfortune of being one of those people, you can have your data shared with the Home Office. So the effect of this policy is pretty clear on women. So women live in fear and are unable to escape abusive situations for fear of deportation. This is despite the fact that many women come to the UK, maybe not out of choice. They don't know their immigration status. They don't know, they weren't involved in that decision making. And secondly, as Zoe sort of mentioned earlier, it means men can exploit the fact that they know that their partner's immigration status is precarious and threaten them and kind of tighten their coercion and control over them. So this super complaint was launched in 2020. A report came out in response from various state bodies agreeing that there should be an overhaul of the laws and policies on police data sharing with the Home Office. In the response, the Home Office conducted a review and engaged in consultations with victim support groups, including Liberty and Southern Black Sisters. And in the consultation process, Liberty advocated for a complete firewall. So that was a complete prohibition on data sharing. There's no need for it. The police should focus on safeguarding people and punishing, removing the threats from society. They should not become pseudo-immigration officials. In December 2022, the Home Office published its response, which was pretty disappointing. They rejected an outright firewall. They suggested they could have a time-limited kind of moratorium or pause on sharing that data so that women can have a chance to regularize their status. But this is something that Southern Black Sisters and Liberty and other victim support groups completely oppose, because the reality of when you are in that situation and you've made a 999 call is that you are just trying to survive. And the idea that you would kind of understand what's going on, find an immigration lawyer, find support groups, especially when there's very few legal aid lawyers out there, is not realistic. So although small progress has been made in this is, and I can't sit here and say they managed to change the law in this area, it definitely sparked kind of a light in me, and I was in corporate law before that, and then as soon as I qualified, moved into human rights law to work on this kind of thing. And this is why I now work in a migrants' rights firm. So in my current practice, I'm just going to give one more example of the hostile environment. And again, there's not been structural change on this issue, but every time you represent one person and you're able to avoid this policy affecting them, it's a huge win, it feels. So another part of the hostile environment is, although all women in the UK are entitled to NHS maternity care, regardless of immigration status, the government has introduced charges for hospital treatment for some patients who were born overseas. So that includes maternity services, including antenatal appointment scans, postnatal care. So women can face bills of up to £7,000. The charges apply even if you have a miscarriage or stillbirth. And what is so infuriating is if there's a British dad, a British child, because the child was born here, but a mum born overseas, the mum is liable for those maternity costs, which is just outrageous and makes me have to lower my voice because I get really angry thinking about it. And the problem is, if you have an unpaid debt of £500 or more, the NHS can alert the Home Office, and although it won't affect your leave while you're in the UK now, it can affect future applications. So women have these impossible decisions to make between protecting that unborn or newly born child, or being potentially deported out the UK eventually. And it's just unimaginable. So although there have been attempts to judicially review this policy that have been unsuccessful, the difference in outcome for a woman who has a lawyer compared to not is staggering, and it shouldn't be that way, but there's usually a loophole you can get them out of paying this charge. So every time you represent, not always, but every time you do and you're able to get someone off it, it does feel like a huge way that they've been able to start being a mum with so much less stress and just complication and a horrendous other outcome that they could have had. So that's hopefully, although a bit of doom and gloom, not all doom and gloom. And I think as women, we experience everyday, sexism and abuse in public, but so much of the abuse women face is behind closed doors and invisible. And that's all the more when women are undocumented and are scared to kind of access public life in the same way as people with citizenship or documents. So it's an important, as lawyers and human rights, that we continue to work to make women's discrimination visible and to try and give women more choice and power over their lives, no matter the situation they find themselves in. And this can be done on large scale systemic changes, but just doing that everyday work of helping an individual client who comes across your desk can change their lives and help make women suffer less in silence and have more control and power. So yeah, I hope that was going to inspire you all to carry on the fight, whatever kind of area that you are interested in or find yourselves in. So thanks.
Yeah, thank you, Katie, for talking about the intersecting factors coinciding with migration. I found it really interesting, especially the impacts of the hostile environment legislation as well. So our final speaker is on screen, Sarita Ashraf, a barrister at Garden Court Chambers, who will be joining us online. Sarita is a specialist in international criminal law with expertise in the gender-competent intersectional analysis of the Commission, as well as the impact of international crimes. Sarita has extensive experience working in the UN system on cases in both Syria and Libya, and has also taken on the role of counsel at the International Criminal Court. Take it away, Sarita.
Thank you for the introduction, and thank you for having me. I'm sorry I couldn't be there in person. I'm at home in Trinidad and Tobago at the moment, but we'll hopefully be back in London when it's a little bit warmer, because I can no longer deal with the British winter temperatures. Yes, as the introduction suggested, I'm going to be speaking a little bit about girls' human rights in the context of international crime and mass atrocity, which is the area that I work in. One of the challenges in working in international crime situations of mass atrocity is that there are a number of groups which tend to go unseen. Among those groups, very clearly, are children, both boys and girls. As is being broadcast across our screens, into our phones and laptops daily at the moment, we already know that children are among the principal victims of violations of international human rights law, but also international humanitarian law and international criminal law. And what they may suffer may, in fact, amount to crimes such as war crimes, crimes against humanity, and even genocide. In 2020, Save the Children produced a study which said that children are disproportionately impacted by situations of war and mass violence, and that in 2020, 415 million children, which was 1 in 6 of those living in the midst of armed conflict, were living in the midst of armed conflict. Of those, 149 million lived in high-intensity conflict zones, which is conflict zones with over 1,000 battle-related deaths per year. We expect in this year's report, obviously, those numbers are likely to be higher, tragically. Children also constitute half of the world's forcibly displaced populations, with all the challenges that go along with it, some of which have been discussed by earlier presenters. So I work mainly in documentation of violations of human rights law, violations of international humanitarian law in situations of mass atrocity. And that documentation does several different things, one of which is it brings it to international attention with hopefully a degree of nuance that allows policymakers, that allows advocates, that allows activists to raise these issues. The provision of information to activists, including activists who are working for girls' human rights, becomes particularly important, because for marginalized communities, including notably girls, the need to push forward so that politicians, those who walk in the corridors of power, take decisions that support justice, humanitarian initiatives for that community, is incredibly important, because often without those advocates, those issues become lost. It's also because I also do documentation to support case building for accountability purposes. And that can be at international courts such as the ICC. We saw, for example, in some of the recent cases in Uganda, this emphasis on looking at forced marriage of young girls and older girls. But it's also now really about cases in national courts. There are so many more situations of mass atrocity than there is space at the International Court to deal with. A lot of the situations don't have jurisdiction at the International Criminal Court because their countries haven't signed up to the Rome Statute. And so now we spend a lot of time working with national prosecutors, including in the UK, in France, in Germany. And a lot of those cases are beginning to focus on crimes against children, but also particularly crimes against girls. In practice, accountability mechanisms have been very adult-centric and have failed to prioritize what are called child-sensitive approaches to investigations, what I tend to call age-disaggregated approach to investigations. What does that actually mean? It means that in investigations of international crimes, the emphasis has been on what happens to adults. Adults tend to be the ones who are interviewed. They speak about what happens to other adults and to themselves. And generally, children are kind of seen on the outskirts of the documentation. Within that, there's also layers of visibility and exclusion. Often it's adult men, actually, whose experiences are most likely to be recorded, to be investigated, to be placed in investigation plans. Where children are mentioned, we're more likely to hear about older boys over, for example, 15 years old, who are sometimes grouped together with adult men, and so rendered slightly invisible in that way. But girls in particular are often frequently unsituated and ageless without their intersecting identities being specified. And so I can break that down. Often when we speak about girls, whenever girls are included in the discussion, which is often not as much as you would expect, given the harm that the harms that are done to kind of girls in particular, they're usually not placed within a particular context. Either they're unseen or they're seen very unidimensionally. So when we are documenting crimes against girls, often you will see more visibility with girls who, for example, are over the age of 14. Girls under the age of 14 generally often are unseen. For girls that are being seen, which is often the older girls, they're often seen really in the context of sexual violence. And so this link has formed, saying, for girls, they're victims of sexual and gender-based violence. Boys are victims, for example, of killing crimes or torture and detention. And so we don't really see the nuance and often the really broad spectrum of crimes that are committed against girls and very young girls in particular. I remember speaking to one academic who was studying the phenomena, Dr. Alison Bissett, and she had said it's the young female child is the one who's probably the most lost when we try and find the voice of children in post-conflict situations. That is the person who disappears. One area where the girls don't disappear, however, is around often fundraising advocacy. So if you look at any of the messages that go out over social media, often by organizations doing great work, including, for example, UNICEF, often highlighting very important aspects of the conflict, they will often use photos of younger girls. And that is partly because in fundraising is often desperately needed for humanitarian purposes. But it's also true that it is photos of girls and young women that tend to raise the most funds. And I think that's, again, layers into this question of people who are girls being particularly vulnerable, but not necessarily centered in the discussion around justice and accountability, or even in distribution of humanitarian services. The greater seriousness with which we view, investigate, and litigate crimes that happen to affect adults more than children and males more than females reflects the value that society places on different groups. So patriarchal and adult-centric structures not only inform the commission of the crimes, but they really also inform the international community and domestic bodies' response to mass violence. And so documentation then becomes really important when it comes to the recognition of the crimes for crimes committed against or directly affecting marginalized groups, because impunity for these crimes tends to reinforce rather than challenge pre-existing norms and patterns of discrimination, both inside and outside the context of war, but also surely in domestic context. I often say you can't prevent and punish what you don't recognize. And when it comes to crimes against girls in particular, and particularly young girls, those crimes don't get prevented very well, and they certainly don't get punished with the same rigor and vigor, because they're often not recognized, because the victims of the crimes are cloaked in invisibility because of the lack of value that they are often given. It's particularly important that we focus on girls' human rights in situations of mass violence and mass atrocity. Along with other adult members of society, they will have suffered violence. However, their exposure to war and violence is more likely to have far-reaching and long-term adverse consequences on their ability to access rights and their overall development. In particular, the conditions they experience as children will heavily affect their physical, mental, and psychological development. I'm just going to close with two examples, one of which is the Yazidis. Yazidis are a group in Iraq that were attacked by the armed group, the Islamic State. Often we think about the Yazidis, if you know anything about the Yazidis, you will know that the women and girls suffered sexual enslavement and sexual slavery, and that is generally what is known. That's very true. The stories are very horrific, but it's also really important to understand that they suffered many more crimes and sexual violence, and that the services that were offered to female victims of sexual violence, of torture, of starvation, of beatings, are not as available for girls as they are for women, because there are no there's no focus and funding for the rehabilitation of girls. And so it becomes really difficult when those services aren't provided and you have these girls who suffered long-term, prolonged sexual and physical abuse. I'm going to skip towards the end because I know we want time for questions. And I just want to say three things about, well, this is what the problem is. How do we tackle this problem? It's, how do we've identified the problem. They're probably not that surprising for those who focus domestically. I'm sure you have many of the same themes. The first is, one, we really need to seed an intersectional approach in any of the work that we're doing. Any of the work that we're doing, the domestic or internationally facing, this is not just about binaries of male or female, young or old, able-bodied or persons with disabilities. Often we need to pursue an approach which is more intersectional, which really understands how marginalized identities interact to create kind of webs of oppression. So when we speak about, for example, girls in Afghanistan today, of course, we will look at the impact on girls who are older, girls who are younger, how that impacts on their right to education. But we may also look at how this impacts, for example, girls from different ethnic communities. How are the Hazara girls impacted versus the Pashto girls? How are girls from rural areas impacted versus girls from urban areas? How are girls from kind of more upper class backgrounds and middle class backgrounds affected differently from girls from working class backgrounds? And in that intersectionality, we bring out the full understanding of how crimes against girls, violations of the human rights of girls are designed, are committed, and their impact. there are two other things I'll just say. One, when we're talking about how to move forward, intersectional approaches is one. The second is creation of expertise specifically in the rights of children, which exists more firmly in domestic systems than it does in international systems. And the third and final thing is the creation of child advocates, especially older girls who can be I think supported and bolstered in their ability to give a window in adult spaces into the views of children. Often it's not possible to do that with younger children for reasons that are obvious, but for older girls and older boys, they can perform an invaluable role in really, I think, bringing forward a point of view which is often lost to those of us who are working, those of us adults who are working on international crimes against children and against girls in particular. Thank you.
Thank you so much. That was really insightful. And I think championing intersectionality for a lot of us here in the room, we're women, but we're also part of our racial or class sort of categories, and that affects our journey. So that was really, really insightful. Thank you to everyone on the panel. I'm genuinely so excited to start the Q&A and to hear everyone's thoughts in the room. So please, we are opening up the floor. Yeah, first question.
Thank you so much for your extremely insightful talks. I'm so grateful to be able to learn from you. I guess my question is, from your practical experience, to what extent do you think the law can be divorced from politics when it comes to securing human rights? I think we can see it on an international scale with the ICJ preliminary ruling, and we can also see it on a domestic scale with the Rwanda Supreme Court judgment. You might have a really sound and solid legal argument, but can it really have significant effects in upholding human rights when the political sphere is not kind of in accordance with that? So do you have any comments on the interaction between the two, and do you ever think that the law can be divorced from politics?
Can you hear? Brilliant. I can perhaps start with that by saying one of the really important things that law does is protect minorities in a majority system. So our current political system is set up so that the majority in Parliament gets to kind of have their way and push laws through. And one of the important roles of law and human rights law is to protect the minority view. And we certainly see that in protecting migrant rights, where there's a real kind of swathe of negativity towards migrants in Parliament, which may not, in fact, be represented in the public. But it's really important that migrant rights are guaranteed, and law has a really important role to play in that. But it's not either or. So, for example, with the Rwanda litigation, the law, the legal actions were extremely important in stopping the flights and protecting people from being sent to Rwanda where they might be at risk of human rights abuses and trafficking. But what is equally important is the groundswell of public opinion. One of the reasons it's in the press a lot is because people are scandalized and outraged that this could be allowed to happen. So the two go together. And certainly, lawyers will work with NGO groups, so NGOs will do sort of public campaigning. Freedom from Torture has done a lot of campaigning on this issue, whilst lawyers use the tools at their disposal to protect minority rights through the court system.
Okay, I hope this is working. It should definitely be separated, law and politics. That's why the separation of powers are there. At the same time, at the moment, I think they're not. And I think there's this phenomenon, which is, well, NGOs call it securitization, at least in the West. In the global South, other terminology is used, like criminalization of dissent, criminalization of status, criminalization of identity. And what we see is the use of public emergency regimes for then states to come in and change law by decree without any oversight. And that's a big problem. We see it under the frame of terrorism, we might see it in the frame of climate change. We saw it under COVID. So I think this is a, how can law be divorced from politics? It should be divorced. I think right now we're seeing a very complicated moment where we need to challenge that better in courts. We also see the co-optation of, human rights all the time. So that's also something that we need to do in courts by politicians who use the language of lawyers, use the language of human rights activists to push through their anti-rights agendas. So I think that's a really important question. There's a lot to be done, and I hope that this crowd will be part of the future generation that does that work. Thank you.
I know there are probably other questions. I just want to say very quickly. I mean, I think it's probably good to define what we mean by politics. And I'm very suspicious of situations where there's an either or, because it's usually a little bit more nuanced than that. I do think legal situations, like once you're in the courtroom, there can be a lot of clarity, and the law can actually serve to champion minority rights, give a voice to people who are not heard. But the law is also made up of people. And so people's political viewpoints, affect decisions about how they might present a case, what they might lobby for. For myself, I do a lot of work, for example, on gender justice. I've just come from a conversation about the new draft Crimes Against Humanity Treaty, which is not yet in negotiations at the UN, but will be incredibly important. And one of the things that I and many other fantastic people, mainly women, but not only women, are doing is really talking about the need to seed essential gender justice more firmly into the articles. Now, I think a lot of people would say that is really political. It's a political viewpoint that is being put forward. I think we would say, of course, it is a vision of a world that we want to seed within the treaty, but it's a vision of the world that's seeding the progress we've already made. So we're not going forward in time saying we want this future world to be seeded in this treaty now. Very difficult to convince member states to do, but saying, look, in the last 25 years, we've made so much progress and the treaty doesn't reflect that. And so I think when you're discussing this division between law and politics, I'm not sure about how separate they are. I think it kind of depends on how you define politics and what precisely you mean. But I think there is that interplay between what happens in broader society and public life and political life and the progress that we're being made and the regressions that may be happening, unfortunately, and then how the law begins to absorb those in its framework, in its legislation, and then eventually in its courtrooms.
Thank you so much, and thank you for your question. Are there any more? Yeah.
Hi, I'm Rhea, and I wanted to ask, how do lawyers and NGOs tackle the rejection of the jurisdiction by states when there is human rights abuse?
Sorry, can you just repeat that? I missed it. The rejection of jurisdiction by states?
Yeah, when there are human rights abuses.
I mean, in some cases, I'm not sure this is a question for me. This might be a question maybe for those working domestically. I can say for the international work, often we don't manage to secure jurisdiction just because legally jurisdiction isn't there, for example, at the ICC or with the ad hoc tribunals. And then there are often parallel movements in national courts about trying to have courts seize jurisdiction in their own territory. The question of whether there's jurisdiction is probably a bit different from the question of whether then states take it forward. Often jurisdiction, it's a legal matter. And so when you don't have jurisdiction, you kind of have to find another route. When you have states that have jurisdiction and then are not taking action, that becomes obviously much more upsetting on a personal level, but really gives rise then to much more innovative approaches from lawyers and activists who support lawyers about how then to push forward through public advocacy and then through private meetings. Often for me it means kind of either convincing people to do the right thing or embarrassing people until they do the right thing. That would be my summary. But those working more firmly in the domestic sphere might have more nuanced strategies than the internationals.
I suppose I can speak to that. So I do a lot of work in terms of jurisdiction in relation to forced marriage cases when there are young children or when there's parental abduction. So usually jurisdiction is a matter of law. And it can be physical presence, or there's like lots of different other ways to acquire jurisdiction, or if they have nationality here, so if a child is a British citizen, then we can take responsibility then. I think the difficulty is sometimes when the state isn't taking responsibility, and then trying to then see if there are creative ways of saying, well, actually, it is the UK that has jurisdiction. That can be a really complicated argument in the family law setup. Usually because it means that if a family settled here and there's like another state involved, well, actually, how do you then determine whether that this state, so in England and Wales, we should be the right court to take responsibility over that child, for instance, if they haven't been living here for that long. But then obviously then you have cases where if we don't take responsibility and another state won't take responsibility, and we're then the next closest jurisdiction to need to take responsibility, in those cases we will step up. But these are really, really complicated arguments. I feel like your question is like very, very high up there. A lot of lawyers could debate about this for hours. And I feel like I've probably given quite a fluffy argument, but just to kind of give you a bit of a specific example, for instance, if there's a girl who isn't a British citizen and she's in the UK, then we would have responsibility, right? So the UK would have jurisdiction to make any forced marriage protection orders for that young person. If they've left the UK, we'll still have jurisdiction because they've been here, but then it's a question of enforceability. So it's then very difficult to then say, okay, this girl who may be an Indian national, she's left our country, but actually, how do we then ask India to return this young child? So it can get very complicated. And then there are rafts of like not just issues of human rights there, but it's more the right of the state. So it can be complicated, but there are ways of going around it, and you normally get people like Sultana Casey to step in and help you.
Nice plug. Thank you.
No, hello? Oh, yeah. I was just gonna add. Yeah. Okay. So I was just gonna add, when you're faced with kind of the policies that I was sort of talking about, where it's a massive issue that affects lots of people, then often there's lots of NGOs and activists that want to bring a strategic challenge. And then when you have the will, you have the policy, but then there's so many legal and practical barriers to even bringing a case. And that's so the example I'm thinking of is a lot of supply chain due diligence or kind of trafficking within a supply chain. And jurisdiction is one issue that can often be an issue, but there's also funding and does the claimants all have the right kind of set of legal facts that you need to bring a good case? Do they have the ability to bring the case before the courts, what's known as standing? And there's just so many issues. So it's just one of those things that when you have the NGO and the lawyers all wanting to, you have to think really, really creatively. And it's often that you take many years and lots of time to get the right client, the right set of facts, and then build those arguments. But I kind of see where the question's coming on from, where you can see a massive injustice and you just want to be able to have your day in court, but it often takes a lot of creativity and time and willpower to get to that.
Yeah, thank you so much. Unfortunately, that's all the time we have now for questions. But we'd like to thank all the panelists for coming and some insightful talks. And thank you all for joining us as well.
Thank you, everyone. Thank you so much to the panelists, and thank you, Sarita, for joining us from a far sunnier place. Perhaps we could have a Girls' Human Rights event where you are next time. I think we all need a little bit of sun. Okay, I'm going to introduce you back to Justina again, and we have a special treat in store. I'll hand over. Justina?
So I know it's been a long afternoon and we've heard from lots of